Okay, sorry.
Okay, so you are in a highly regulated environment with the government, and there's also a lot of mistrust in the government today. So with the amount of regulations and the pace of life, it is easy to make mistakes, but don't be demoralized because you also have a chance to make a difference.
Not like we have pizza. There we go. Did it work?
Yep.
Okay.
Yep, now we're good. Making a difference though, especially with the mental health practice right now. You have to recognize that you can't fix everything. You have limited resources and you also have competing demands. So when you are considering new proposals or funding agreements, you have some questions to ask yourself. Ask, who do you represent as a board? There's a lot of theories out there, the Federalist Papers, there's different theories that you can do, but you just have to think, are you representing all the people? Are you protecting, how do you protect minority rights? Are you protecting those that are most vocal or that don't have a voice? Ask yourself, can you please everyone? And the answer to that is no. Should you try to please everyone? The answer to that is also no. Think about, do you answer to the loudest voice in the room? And then also ask yourself, what is your role as a board? You have to balance purpose with means. As a board, you should speak with one voice, and you should have clear lines of authority, clear lines about who should carry out what, and clear lines as to what the board expects to happen. And then also just remember, you can dissent, but after the vote, don't undermine the process. I think we have, sometimes we have issues with that where you want to carry through with what your personal position is, but you're acting as a board. And then how many of you have professional staff versus the board doing the legwork? Okay, so here's some tips for working with professional staff. You do have the right to expect good communication, responsiveness, information, but also let them do their job. And let the executive directors do their job and let the employees do their job. You don't want them to have 7 bosses. And you want to have, whatever your structure is, you want it to be clear so that everyone knows what to expect. Also, as a board member, don't forget to read your packet. This really helps with running efficient meetings and it helps with professionalism. If you have questions of staff, ask them before the meeting. That will help run an efficient meeting. And then it also gives them a chance to respond. It doesn't put them on the spot. And this one's always just a good reminder, be civil. Remember, reasonable people can disagree. Reasonable people can have differing opinions. And you can disagree and not be disagreeable. So just keep that in mind. And if there is a specific topic that there's going to be varying opinions on, consider having a strategic planning session or, a meeting where you can work that out before you have to do it at a vote. And then again, remember, once the vote is taken, you're acting as a board. So move forward as a board, regardless of your personal position. We've labeled this the business of government, but government really isn't a business at all. And that's sometimes frustrating for newly elected or newly appointed officials. It's deliberately not designed to move quickly or cheaply. And there's different lines of authority in a business versus a government. It's less concentrated power in a government, and it's done collectively. And sometimes it involves politicking, lobbying, and compromise. And there are regulations specifically to government that do increase the costs of doing business, and it also decreases flexibility. Government decision-making is supposed to be transparent, and it is supposed to be scrutinized. So these are just things that you need to keep in mind when you're trying to do your job and you get frustrated and you feel like you can't do your job. This is all part of the process. We'll talk about FOIA and OMA later, the sunshine laws. And those are things that you might, again, get frustrated with, but they're really to increase transparency. They may limit creative problem solving. They may encourage people to play to the media, but that's just part of your job. Also, you need to recognize that government isn't measured by profit. The purpose of a business is to show a profit. The purpose of a government is not. The purpose of a mental health board certainly is not meant to show a profit, because all you do is provide services. You don't make any money. And that makes the success of a mental health board difficult to quantify. So this is also something to think about. How do you measure your success? Taxes are really difficult to compare to services, and the result of that is it makes taxpayers, it makes your customers have the ability to say, we want more mental health services, but also we want to lower taxes. So it's just, you just have to keep these things in mind when you're trying to do your job. And Brad's going to get more into the actual how to do your job part of it. Also, unlike a lot of businesses, leaderships change regularly in government. You have staggering terms and you have elections that affect who's going to be appointed or reappointed. So recognizing these differences between businesses and government is going to help you compensate for them. Here we've just listed some criteria that may be helpful when you are making decisions. How many residents are going to be affected? How will it help? What will it cost? Will it adversely affect residents? And then here are some measure of successes also. Brad, you're playing with it.
Oh, did I do something?
Yes. What did we do?
I had just pulled up the chat screen to make sure there weren't issues. I feel like I just got scolded.
He did.
There we go. Did that work?
Yep.
Did it work out?
No, my clicker's not working though.
Oh, sorry, go ahead.
Is that where we went?
Yeah, that's fine. So like I said, here are just some measurements of success. Sorry about that. So you can consider, is it the number of programs that are funded? Is that how you're going to measure success? Is it the amount of money that you're providing? Or how much does providing these programs increase the desirability of people living there? There's a lot of different measures of success. So just think about what are your criteria. And then just also a reminder of how important communication is. Help your public understand what you do. Yes, your meetings are open to the public, but that's just the beginning. Do you put your information on the website? Is your packet available ahead of time? Do you have online streaming of your meetings? That's a thing now. Everybody can online stream it. Do you provide a newsletter? What's your public participation at your meetings? Have reliable procedures so that when people do come, that they know exactly what to expect. And then if you have a website, try to keep it up to date. That's a great way to provide people with information. So with all of that theory in mind, Brad's going to talk to you about how to actually run your board, how to make a motion and that type of thing. And then I'm gonna come back and talk about some Open Meetings Act and FOIA. And then if we get to it, Brad's gonna talk about conflicts of interest.
Good morning, everyone. Happy Friday. Brandy had twice said, I'm gonna tell you how to do everything. I'm not, okay? But we will go over parliamentary procedures and what would otherwise be some of the adjoining areas of both kind of legal theory and practice, and hopefully what's also just some practical tips and advices. So we're gonna start with, why do we have meetings, right? Let's start just with that simple question. Why do we have board meetings at all? Well, as Brandy had just said, there's no individual decision maker, right? There's a collaboration of several people who have to reach a consensus on several different items. And regardless of what that direction or decision may be, really, the purpose of the meeting is so that the necessary actions can be taken, right? And as a preface to taking the necessary actions, you as board members would certainly want to have an adequate amount of information to be able to make that decision. So when we talk about meetings, it's really about making sure that it's a mechanism for the board to make informed decisions. That is the purpose. So what makes a good meeting in itself? Well, first of all, people generally prefer short meetings. However, a short meeting isn't necessarily just the defining feature of what's a good meeting. But short, really, I think the key is not so much the brevity, but the efficiency of that meeting. There may simply be times you do need to discuss things in more length. And a board meeting might take 30 minutes one night, and it might take 2 hours another night. And that's all right, as long as it's being run efficiently. But the more efficient it is being run, that's an indication that you and your staff, in many cases, have already done the preliminary work before that meeting, right? It means you've had the information ahead of time, you've reviewed your board packets, you've understood the material. If you haven't understood the material, it means you hopefully have the avenue to ask the questions to get the necessary information and clarification that you need. And yeah, this is a very important point on the prior slide. Sorry, we're having a little bit of technical difficulty, but right here, after 10 p.m. attention wanes. That's absolutely true. And I can tell you an example in this past year where, and this was a municipality, not a 708 board, but spent 2 hours discussing whether a permit fee should be $10 or $15. 2 hours. The next item of discussion, a $27 million new facility. No discussion. Why? Because everybody was glazed over already, right? And that's important, right? We don't want to focus on minutia, right? We want to focus on those things that you as a board should be directing, which should be, especially when you have staff, policy driven, right? You're here to make policy decisions. It's your staff's ability to really take care of some of the details where you have staff available. Now, I do understand some of you don't have staff and you may be kind of doing that dual role, and that's understandable too, okay? And maybe you do need to dig into that minutia a little bit more than some of the other 708 boards, and that's fine. Just have an understanding of that too. And the more information that can be presented up front, distributed to the board members before that meeting, hopefully you can narrow down the amount of time that has to go on that. So now to the next slide. I feel like I should click anyway. Would that be a signal? Like, okay, well, we'll do that. So have a plan going into every meeting. Every meeting should, of course, have an agenda. And part of the Open Meetings Act does require that this agenda be posted at least 48 hours in advance. Brandy's going to go into some of that a little bit later. And as a general rule, the board, well, not a general rule, this is the law. You may only take action, formal action on items that do appear on the agenda, okay? And that's because if you're a member of the public, they should have the right to be able to know what's on that agenda, what action may be taken, and the right to basically participate in the form of attending the meeting, making comments during the meeting, which we'll also talk about how that can and can't be done. But that is a requirement. So can you talk about other things in a regular meeting? The answer is yes. Whether or not it's on the agenda, you can generally discuss other topics. However, a special note there, if you're holding a special meeting, meaning not one of your regularly scheduled meetings, only discussion that is allowed relates to that which is on the agenda. So you can't go off course with that. So another thing is the agenda itself would generally be set by the chair of the board. There's different ways to go about this. We're going to talk about next a consent or omnibus agenda. And what this is this is a mechanism to potentially make your, let's just say, some of your more routine action items every month voted in one action instead of necessarily having 5, 6, potentially more different items that you have to then have separate motions and discussion on when it may not be necessary. So what, does anybody use a consent or omnibus agenda currently? Okay. I see a couple hands. It's not a requirement. And I said consent or omnibus. They are the same thing. Okay. You just hear them, that terminology used in different ways. So if you hear one, it means the other. But what it means is you could have, for example, approval of minutes, approval of bills, approval of, what would be another example that would typically fall? Maybe the schedule of meetings for next year or something like that. Things that would be considered perfunctory or things that you would do as a matter of course unless there was some issue. You can list them all just under that consent or omnibus agenda. The beauty of that is it means that there's one motion, it gets seconded, there's no discussion, and it goes right to a roll call vote. The vote itself does not need to be unanimous in order to pass the entire agenda, but you will see this note that says that the single vote need not be unanimous. However, the official must be given an opportunity to remove an item from the consent agenda. And what this means, because it's a little bit confusing, is everybody has to agree to the items on the consent agenda, but not everybody has to agree to vote in favor of all the items on the consent agenda. And typically how we do this is right before the consent agenda is presented, the chair should simply ask, is there any board member who wishes to remove any item from the consent agenda? If they do, it automatically gets pulled off the consent agenda, and then it would be discussed as its own separate item later in your meeting agenda. Okay, but again, it has to be unanimous, and that's why one person has the ability to remove anything if they want to discuss it, right? Or maybe they want to vote a particular way on one item without necessarily tanking the rest of the consent agenda. Hopefully that makes sense, but if you're not using one, you can certainly consider doing that. You know, also as a board member, it is important that you come to the meetings prepared, right? Especially where staff or fellow board members or the chair have put a great deal of time into putting a packet together. The purpose of that packet is to give you information to allow you to understand what you're being asked to vote on. And to really do whatever research you need to do in advance of that meeting. Now, there's a fine line here, and I'm thinking of those again more with staff. If you have staff, please don't second guess, get into the minutia on every single detail, right? For example, the list of bills indicates that there was a $3.95 expense item. Doesn't matter. And I'm not saying don't be financial stewards, don't be looking at things, but to blow up like the entire list of bills or to make staff spend perhaps hours or get other board members involved in things that in themselves are not problematic. Just be sensitive that this is, time is money to the agency too, right? And is that the best use of time? And I want to just backtrack a bit. I'm not saying don't look at your expenditures. By all means, do look at your expenditures. Just, really take it in stride that there are going to be ongoing regular expenses. And unless there's something that really jumps out as a bit of an aberration or something you think can be improved in terms of a more efficient way to do something or economical, then, maybe that's not the best use of staff's time to go fetching, various documentation for why somebody paid $1.80 at the toll booth on their expense report, as an example. Okay. Also during the meeting, and I think I said this a couple of times already, and thank you, Rain. Really try to stay on task as much as possible. It is absolutely understandable that sometimes discussion on one item might dovetail or kind of segue into another topic of consideration. That's fine, okay? But keep it confined to what that is. If you really start wandering into a separate area, a separate issue, a separate policy, perhaps that's something that should be addressed in a future meeting agenda, right? Instead of one person kind of dominating a meeting, talking about something that really isn't what's brought before the board the evening in question. So as much as possible, and it really is the chair's role to govern the meeting, so to speak, just try to if you see things are going that way and you're going into a 20-minute discussion about something that's a little bit off topic, maybe just try to redirect that in a way that you either go back to the topic, or if it looks like something that more information is needed, or there's a whole other issue that needs to be addressed, maybe that's an item that can be researched more, information can be distributed to the board prior to the next meeting, so it doesn't become just a free-for-all. I'm not sure if anybody's ever experienced that, but it has happened once or twice in board meetings. So also, just a related point on that is all right to ask staff to follow up on things, right? That's actually perfectly appropriate. It's actually preferred. And I don't know if we're otherwise going to cover this premise through our presentation today, but I think it is a very important message that, when we're dealing with staff, and especially if there's information you may not feel like you're getting, or it's not enough information, as much as possible, try to address those concerns outside of the meeting. We don't want to criticize staff publicly. That really creates a lot of animosity. It creates a lot of uncomfortableness, I think, for staff to be able to do their jobs. Not saying that every staff person ever in the world is perfect and shouldn't be criticized or asked to do something more than they've been doing. But is shaming them in a public meeting the best way to do that? Probably not, right? And if it's something that the board as a whole needs to address with personnel, then there's also an opportunity to do that in a closed session, to have that discussion in a way that again isn't publicly shaming your agency and your staff. Okay. So public comment is the next, item here. This is again, the Open Meetings Act. Public comment must be allowed during every meeting, whether it's a regular meeting, a special meeting, it doesn't matter. There has to be, and the agenda should have public comment on every meeting. Ideally, it really should be prior to the board taking action. Although that's not technically legally required, but the premise is that the public should have the opportunity to address the board with their opinions, perspectives about whatever they want. And if it is something that's on the board agenda and they want to be heard on that subject, it really only makes sense that that be allowed before the board takes action on those items. Now, several things with public comment, we could probably spend a lot of time doing nothing but focusing on this topic. But, you know, one of the most important things to understand is that you have the right to adopt your own rules for how public comment can be, let's just say, contained, might be the best way to say that. You can adopt reasonable time limits for how long a person can be allowed to speak. 3 minutes, 5 minutes tend to be very common time thresholds that are used. You do have the right to, if you want to have people sign in to speak, to have a sign-in sheet, to recognize somebody to be heard. But you do need to adopt those rules as a board. And especially if you're going to make those special requirements of time limits, then those also have to be put on your agenda. Okay, that's what the public access counselor has said over the years, right? You have to adopt the rules and they have to be, published with your agenda so the public understands that. Now, these are some subtleties or issues that come up once in a while with public comment. I will be very clear about this. You may have an agenda talking about, very important items and a lot of discussion ahead of you to get through those. If somebody wants to come in and tell you how he thinks the aliens are abducting his brain waves and how he's hoping that your 708 board will understand and protest against the federal government, they can do that. Okay, you can't interrupt, you can't stop them, you shouldn't cut them short. They have the right to say what they're going to say with very little, I guess, caution there in that, yes, nobody can be unruly in terms of using abusive, offensive language, that sort of thing. You can have rules that prevent that. But whatever that person's going to say, let them say it. And here's the other thing. Public comment means they have the right to speak to you. They have no right to require you to answer, to respond, or to engage in argument. Our advice, a lot of this. Nod, smile, thank you for your comment when they're done, okay? Just let them get through it and try very hard not to engage. Yes.
Question on time limits for that. Is there a time that, I know for a county board meetings, they have like a 3-minute rule and a written document to be presented in that time.
The written document, I'm sorry, I didn't. Oh, yeah, so as far as, so they have to sign in and say what they're going to talk about. The reality is you can ask them to do that. You can't require them to. You can keep them to the time limit, but you can't make them tell you what they're going to talk about. No. No.
Would you put their comments in the minutes?
Yeah, great question. And for those on Zoom who maybe didn't hear that, the question was, do you have to put the public comments in the minutes? Our suggestion would be this. Joe Smith wanted to talk about aliens, right? whatever the topic might have been. I mean, I would summarize it in as few words as possible, just so there is a record. It was said, but, and I've seen this, where there's frequent flyers at some board meetings that like to talk every time. You look at the minutes and you would think it was their board meeting. You know, it's a page and a half about this, you know, everything this person said during the meeting. And then there's a consent agenda. Everybody voted in favor and two people said a couple other things, but I mean, like half the actual minutes are public comment. So I don't think that that's necessary. I think it's actually somewhat of a distraction if you're looking at minutes as a historical record, and because the public comment isn't board action, right? It's not formal action. It's just somebody speaking, you know, and they have the right. Yeah.
My last question, so there doesn't have to be like you can have them have a sign up sheet at the beginning of the meeting and stuff. They don't have to do that in advance if the board allows that.
So you can have a rule that says you have to sign in prior to the beginning of the board meeting to be recognized to speak during public comment. That should also be printed on your agenda. Okay, because if it's not printed on the agenda, then arguably the person would be able to say that they didn't know that and they were deprived of their opportunity. Yeah. No, these are all great questions. So, oh, yeah.
Yeah, can you have that on the board notice when you publish it, that, you know, if you intend public comment, please contact the office and beforehand, let us know that you intend to submit public comments.
Yeah, I think that's probably a bridge too far. It's a good question. I mean, I think as a general rule, people during COVID, we had a bit of a really just unique circumstance, and that was a thing where people had to submit remotely just because there wasn't a physical meeting. But in what's the normal landscape, you really do have to allow somebody to walk into that meeting and make a comment. So we can't really require them to pre-screen that or, you know, go through staff to do that in advance. It's a good question though. So then, you know, we're talking about parliamentary procedures here. Why do we bother with these? Well, the simple answer is because without them, we have nothing. Right? There needs to be some formality for how meetings are conducted, right? And well, what if we have to be able to address all the what ifs, and that's really what parliamentary procedure provides. Robert's Rules of Order are the default, kind of the de facto, that whether or not you've adopted them would be considered the governing default procedure, but also understand you as a board do have a right to adopt variations of these rules. So everything we're going to talk about right now isn't necessarily hard set in stone if you actually adopted variations of this, but these would be the general rules and important to just keep in mind. So first of all, it is the chair who runs the meeting. The chair is the person who should recognize speakers. The chair is the person that would call somebody out of order. The chair is the person who announces the next item for discussion, calls for votes, calls for the roll call vote, all of that. The members, however, are the ones that make things happen, right? The members make the motions, they vote on the motions, the chair does as well, but and basically the motion is considered the primary vehicle for how action is done, right? It's the motion. So with that, the next slide isn't necessarily as germane. You as 708 boards really aren't dealing with ordinances, but just understand that there is a bit of a hierarchy in terms of different actions the board may take. So a resolution, for example, if your board adopts a resolution can only be amended or superseded by a resolution. So you couldn't just do a motion to undo a resolution. If there's a resolution, you would have to approve a new resolution to change the old resolution, if that makes sense. And we could probably just go to the next slide. And then let's talk about the kind of the technicalities of making a motion. And understandably, especially for newer board members, this may be just awkward if you've not been in the setting before. But you know, it could be simple enough and hopefully comfortable enough with a few rules here. First of all, the motion is made using simple words, right? It's simple sentence structure. I move to approve, deny, whatever the predicate is, right? Whatever the topic is. I move to approve the minutes from the December 2nd, 2023 7:08 board meeting. That's a perfect. You can also use the language, I make a motion to, so I move or I make a motion to would be the correct terminology. And also, you know, this is very important. I move to approve or I move to deny. So you don't have to approve everything, right? You could make a motion in the negative to deny, but what we don't want is what we call the Taylor Swift motion, okay? Don't say, I didn't warn you, okay? Do you get people starting to
I was
make,
promised there'd be singing.
I was promised there'd be coffee.
Named Woman of the Year.
Well, right, but the problem is, and you may see this from time to time, somebody doesn't want to approve something, but they don't know how to exactly verbalize this. So what do? They say, I make a motion to not approve the contract for XYZ services. Okay, well, that's a real problem because you're voting to not approve something, and then what if your motion to not approve something fails? It becomes just a logical kind of absurdity, right? Did you just approve it because you didn't not approve it? Right, so use plain English. If you're voting something negative, just say, I move to deny it.
Just a quick question or comment, and this happened recently at one of our local governments. A motion to approve an agreement was made, but it wasn't made where I approve, motion to approve, but authorize the president to execute an agreement. And I just want to, you know, that seems to happen more often than not that I've learned. And that might be something to also, when it comes to approving an agreement, you need to authorize either your president or your executive director to execute an agreement in your motion.
Okay.
Because otherwise the motion can get thrown out, as I saw recently, you know, earlier this year when one of our local governments.
So what you're saying is a very good point. And really best practice anytime you're authorizing a contract, an agreement of some sort, would be to really include two elements in the motion. So it's a motion to approve the contract with ABC Company and authorize the board chair to execute the document. Okay, so yes, that would be the best way to do that. Now, you're saying, oh my gosh, how is the board going to know to make a motion with that complexity, right? Because that's two components. Here's the answer. Your agenda should say those words, right? The agenda should say those words. So the person making the motion, assuming they're in favor of it, would be able to just read, I make a motion to approve the contract and authorize the chair to sign, right? Great point. All right, we done with Taylor Swift? No. Okay, yeah, and these are just some other, just pointers to keep in mind with parliamentary procedure. it's technically improper to make a motion, for example, to approve and then vote against it, or, the opposite. I've never seen something actually get invalidated for that reason, but technically that's not proper under Robert's rules. It's also, sometimes you may want to adjust something, right? Or maybe part of your approval through your discussion, starts to kind of lead the board in a direction that's a little bit different from, maybe what was originally presented. Or sometimes maybe staff's even looking for direction from the board, and maybe the motion does kind of need to be crafted or customized through the discussion with the board. And I don't know if we just discuss this first, but there was an old rule of parliamentary procedure that you couldn't have discussion on an item until there was a motion and a second. That's outdated, okay? And I think for the most part, most boards still follow that practice, and there's nothing really wrong with that as a general rule. But just understand for the chairs out there that sometimes there may be an item that does need kind of that organic discussion and development, to maybe really hone in on what action should be taken. In those cases, it's perfectly all right to introduce the topic, not ask for a motion, and say, before a motion is presented, I'd like to entertain discussion, and then let, the board speak about the topic. Just so everyone knows, okay? So also, and just so everyone knows this, the second is required, right? You can't just have a motion, it does need a second. And it's after the second, that again, traditionally, the discussion would follow that. But however it's done, if discussion's before or after, then it goes to the vote, as the chair would ask for typically a roll call. For the most part, just assume everything's a roll call vote. Doing roll call is never improper. The only time you can get in trouble is if you do a voice vote, meaning ayes, nays, and abstentions. And it's something that did require a roll call vote. Really, the only voice votes that are allowed would be for very, very routine things. We're talking about a motion to adjourn. We're talking about moving to approve minutes. That would be about the extent of where voice votes are allowed. So by default, assume everything's a roll call vote unless you're very sure it's something that can be done by a voice vote. Make sense? Okay. People on Zoom, make sense? Okay. And then, yeah, okay, so are we on amending? Sorry. Yeah, perfect. So this is another one of these very just complicated things that people get very confused by, and it's understandable. Once a motion has been made and seconded, that motion needs to be voted on, right? The only exception is if both the movant, the person making the motion, and the person making the second withdraw their motion, okay? That would be the only way it doesn't proceed to vote. Otherwise, what happens when we make a motion to approve new curtains for the boardroom? Or I guess we'll use the example up here, but somebody wants to change the color after you've had the discussion on it, okay? Well, the answer is we do a motion to amend. And what that means is it's a motion within the original motion. So you start with a motion, let's just say, I move to approve new curtains for the cost of $300 for our boardroom. Get seconded, discussion. Somebody really brings out the fact that fuchsia is the new color that they really want to go with. So then somebody can then make a motion. Well, I move to amend the motion to require that the curtains be fuchsia. So that motion then gets made, then that needs to get seconded. Then there's discussion on the motion to amend. Now we're in the motion. And then that gets voted on. If it's approved, then we go back to the original motion and it has been amended, right? So now the board is voting on the entire motion to now approve fuchsia curtains for $300. Okay, and then they vote yes or no on the original motion as amended. If the amendment got denied, then they're voting on the original motion without the amendment. Totally makes sense, right? Yes.
So if there's an additional amendment that wants to be made, is it considered a second amendment, or are you amending the amendment, or?
Well, it would depend actually, and God help you if that ever happens. But let's start with this premise, and I've done this before. The short answer is yes, it can be done, and it could either be a separate item entirely that's a separate source of the amendment, or you could be moving to amend the motion to amend itself, right? So it could take either form. If you ever get in that situation, I would just say, hey, can the person making the original motion withdraw, and the person making the original motion or seconding the original motion withdraw? If they do, let's start with a clean slate and just say, if this is what we're gonna do, let's just make a fresh motion without all the convolutions. And you can do that even with a motion to amend. You could do it, you could handle it the same way if you don't want the motion in the motion. Yes.
I just want to make sure I have this clear. So if person X makes a motion, person Y seconds the motion,
Mhm.
can the other board member Z make a motion to amend?
Yes, that's correct. Yes.
That's what I,
Right, and understand, nobody has voted at that point, right?
right.
Right. Okay, so, yeah, that's one of the more convoluted areas. Then we get into tabling, postponing. I realize we're probably running a little long here on this segment, so I don't want to take up too much time. But I'll summarize this by saying this. Everybody thinks the word is table. It's not, okay? It's not. When you say I'm tabling this, you don't mean you're tabling this, okay? And what you mean is you want to postpone it, okay? So when you say, let's table this to the next meeting, what you mean is I make a motion to postpone consideration of this contract until our January 2024 board meeting. That's what you mean. Tabling is actually a way to kill an item. Because if it's, you have to, it requires a separate motion at the next meeting to take it off the table, or otherwise it's dead. Okay, so you don't mean table. Or if you mean table, you're being very clever. All right, calling the question, and again, I hope this is something you don't actually need to do ever or frequently, if you ever do. Can discussion just go on too long? Yes, it can. General rules of protocol is the chair is able to recognize each member of the board to speak on any topic. That can be the end of discussion, but really what happens, and it's every board, so don't feel bad if it's yours, is they're more organic, right? And the chairs, there'll be an open discussion, right? And trust, the board member A is gonna say something, and board member B is gonna say something, and board member A is gonna say something back. And generally that's fine, right? That's kind of a healthy dialogue and discussion. It can go too long once in a while, and especially when it's a very contentious topic. If somebody ever truly wants to end the discussion, that's where you would get calling the question. And that requires a motion, a second, and a super majority, a 2/3 majority of the board to end the discussion. If that's successful, then you go immediately to the vote. If it's not successful, then you go back to discussing whatever you're discussing. Sir,
2/3 of those present,
in the case of
not 2/3 of the whole, you have 7 of the 9 commissioners there.
so correct, with calling the question, it would be 2/3 of those present, assuming you would have a quorum regardless. Yeah, right, and 2/3, you always have to round up to that. Yeah. So a motion to reconsider, again, another one of the things that hopefully doesn't come up that often. The most important thing to note, and actually there's a bit of this isn't exactly true. Say a motion's been, just didn't pass, okay? And somebody starts to second guess that and thinks, we really should have passed that. It really should be under Robert's rules, the same meeting. Somebody who voted basically in favor of how it got passed or denied has to be the one to submit it for reconsideration. So it can't be somebody who voted against the outcome that happened that makes the motion. It has to be somebody who voted in the successful direction on that. And if it passes, that doesn't mean you approve the underlying matter that was being reconsidered. It means that you go back to then have a fresh motion, second discussion, and vote on that. Hopefully that doesn't come up that often. And I think we've already talked about all this. It's just once the motion is made, it really belongs to everyone until it's voted on.
It doesn't look like it on here.
Hmm?
Yeah. Same as Zoom as we.
Okay, it might be one. I think it's one.
Okay. And then voting on the motion, this is also just a couple of subtleties I want to make sure everyone understands. So you go through the roll call. The chair, after the vote, should declare, it either passed or it failed, just for the record. So everyone knows you vote aye, you vote nay. You can abstain. Just understand that when you abstain, abstention does not mean recusal. And this is one of the very, very common mistakes or misunderstandings people have. Somebody may think they have a conflict and they abstain from a vote. That's not the way to do it, okay? And we'll talk about conflicts a little bit later. An abstention means your vote is counted, okay? Because if you are in the room as a board member, when that vote takes place and you abstain, you vote present, or you say nothing, it's all considered the same thing. Your vote counts. How does it count? Generally, your vote will count with the prevailing side. Okay, so if something passed, your vote will be considered to have, from a technical standpoint, that means you voted in favor of that. Okay, there's a thing called Prosser's rule. I am not going to bore you with that right now, but if anybody really wants to nerd out at some point, reach out to me later. It's fun. It's a really exciting thing. Just it'll take more time than I think is valuable for our limited time this morning. So yeah, and we talked about this already too, right? I mean, there's very little that we can do by voice vote. So with that, again, I think the segment's running a bit long. I'm going to transition it back to Brandy, who's going to talk about the Open Meetings Act and a little bit of FOIA. Thank you.
So the Open Meetings Act is, just so you know, it's often referred to the Open Meetings Act. It's OMA, it's OMA, so all those things mean the same thing. And what it means is that public business is supposed to be conducted in the open. These are referred to as the sunshine laws, FOIA and OMA, the Local Records Act, because the public business is supposed to be performed out in the sunshine. It's all about transparency. And this means that, business has to be conducted in the open. Notice has to be given to the public as to when the meetings are. And the public has to be permitted to attend. So any exceptions to these rules are narrowly interpreted. And the reason for this is because you're doing the public's work. So the public has a right to know. And essentially the rule is that, the purpose of the Open Meetings Act is that any person can address the public. You have the right to redress. This is not, as Brad said, this is not public participation. You don't have to engage with public comment, but they do have the right to address the body. And there's also, just so you know, a difference between a meeting and a hearing. A hearing, somebody does have the right to be involved and there's due process in that. So what is a public meeting? There's three parts to it essentially. It's a gathering by a majority of a quorum to discuss public business. So this is just the statutory definition. It's found at 5 ILCS 120. So we're going to break down those three parts. A gathering is a coming together of persons. It doesn't mean that everybody has to be in the same room. Physical presence is not required. It could mean on the telephone. It could mean in electronic chat room, instant messaging, texting, social media, conference calls, all of those things. So you have to be careful when you're on email, when you're on social media, when you're texting. And it really is a matter of timing. If it's a contemporaneous communication, it's going to be considered a gathering. So just be careful when you do email, and be careful when you're, as an appointed official, as a member of the board, be careful when you're emailing everyone. You don't want everyone to respond and then for it to become a public meeting because you're gathering. So if you have staff, let staff manage those communications as much as possible, or remind everyone on the email that they shouldn't respond. Or what I typically do is I'll BCC all the board members and I'll put on there, this is being BCC'd so that everyone doesn't respond in order to not violate the Open Meetings Act. So it's not really meant to make your jobs harder. It's just you're conducting the people's business and they have a right to be there when that's done. Political strategy meetings, there actually was a recently binding opinion from the PAC. So if anyone's interested in political strategy meetings. We do have remote attendance rules. If you are going to allow remote attendance, the public body first has to adopt rules allowing it. A quorum has to be present and it has to be physically maintained. And the majority can vote to allow electronic attendance, but it's only for certain reasons. And we have these, oh, I did change it. Excellent. On my sheet, I didn't change it yet. It's only for illness or disability. It's for employment purposes, either for the public business's employment or for your own employment, for family or other emergency. And the new one is for unexpected childcare obligations. This just took effect. So what it does not include is vacation. If you are out for vacation, you can call into the meeting, but you can't participate. It has to be specifically for one of these reasons. And so far, it's only for video and audio. We also have pandemic rules. Since we're not in a pandemic, we're not going to go over those, but we do have specific rules for pandemics. Yes.
So for the reasons that you listed, if somebody attends remotely, and they meet one of those reasons, are they allowed to vote or they're just allowed to participate?
The public body first has to have adopted the rules allowing it, and then the majority has to allow, like you have to say, somebody has to make a motion. I make a motion for Brad to participate electronically. And then if the majority allows it, then they can participate in the meeting so they can vote.
Yes, you could vote at that point.
Okay.
If you're on vacation and you're just calling in, you can still call in, but you cannot vote. You can't participate.
Brandy, just, because it's been a pain point, as you might be aware with Dundee, it has to be the honor system for those reasons.
Correct.
You cannot ask for, produce a doctor's note. If you claim you have a disability, then that word is accepted. If there is some proof to it, it's not your colleague's business to have to ask for that proof. And I think though, if your rules also have it the opposite way, where instead of it's a motion to allow it, it's a motion to object to it. If your rules are set up to object to somebody attending remotely for the valid reasons, I think that's another rule that can be put in place. I know, for instance, Kane County put in that rule. Instead of a motion to allow someone to participate remotely, it's the opposite. You have to object to it and second it and then pass it. So basically suspend an objection.
I would be a little bit leery of that for one reason. And that's simply that, outside of, I mean, there's not even an exercise of home rule authority with the Open Meetings Act. The statute itself does require that affirmative vote. I guess what you're describing maybe is possible in that you could do it in the negative, right? You could just say it's allowed unless enough people say it's not allowed, right?
Right. It's
So-
covered under the rules component of open meetings. Where that is, because I know some boards, for instance, like, they have a limit. You can have by the law, it says you can have up to 4 people remote, but they actually cap it at only 2, even though 4 mathematically could do it. So I mean, it's up to your rules, or as we call it for our mental health boards, our bylaws. And that's why they have to be very, very bulletproof, because sometimes it can be a pain point.
So we'll move on to the second requirement. So first, we need a gathering, and the second is a gathering by a majority of a quorum. So this first column here is the number on your public body. So most of the public bodies for mental health boards are going to be 7 or 9. So it's the last 2. The second column is the quorum, and this is the minimum number of members that you need to make a meeting valid. And then that third column is the majority of the quorum. So if you have a gathering by 3 people, then you could be conducting public business. So if you run into a couple people at the grocery store, don't talk about public business. And finally, the third requirement is it has to be a gathering, the majority of a quorum of a public body. You are a public body. A mental health board's a public body, and any commissions or committees that are formed by the mental health board are a public body. It does not cover your friend's wedding. That's not going to be considered a public body, but don't talk about public business either. It's not going to be applicable to barbecues, that type of thing. But if you think that it's public business, it probably is. Use your judgment or your lawyer's judgment. There are some definitions, but it's not fully defined. So some things that have specifically been included by the courts are any item on an agenda is going to be considered public business. And some people think that if you just talk about it, but you never vote on it, that's not in violation of the act, but it is. You can't avoid the act by not taking a vote and just deliberating. So just be aware of that too. Brad did talk about, sorry, go ahead.
It's very common for community mental health boards to attend agency events. So the agency wants your board or commissioners or whatever, trustees, whatever they may be called, to come to specific events, and they may sit everyone at the table. And so your board has a table, and you are hearing testimonials on programs you fund, maybe with substantial funds. And the table may talk about whoever presented and whatever staff person is receiving an award, or things that are germane to the funding that you do. And the agencies want you there, people want to attend. It's not a public meeting. You're not going to publish an agenda that you're attending the gala for Helping Hands Center for the Disabled. How do you handle that?
So I actually, if you think that you're going and that you're going to be discussing something that's germane to your public business, the conservatives' approach is to publish. Publish that you're going to this gala. If you're not going to publish, and you certainly don't have to, then you can't conduct public business. You have to make sure that your members are aware that we're not discussing public business. You might be being educated about it, and that's fine, but make sure that that your board is not discussing public business.
Could I add to that? It's a great question and I get if it's a third party's event. You can't, how do you post an agenda and have public comment, right? You can't, right? That's not an answer. But what you could do is you could make sure your board is educated as to the sensitivity of the issue, right? And I mean, ways you could approach that, maybe you could have no more than 2 people at a particular table, right? Or maybe you have no more than 2 people in attendance at the event as representatives of the board. If everyone's gonna be there and everyone wants to be there, maybe everyone just needs to understand very clearly that more than 2 of you can't be engaging in a discussion about something that is an affair of the 708 board. And it's a great question, and I don't think there's a perfect answer. I think you just have to.
I mean, you'll go to a ribbon cutting for a new location, and they have 4 of the board members there, and people will come up and ask you to increase your funding, and oh, thank you so much for funding, I hope you'll fund this new project, and you know, and you look at each other and you can't say anything about it.
Well, yeah,
Yeah.
It's not an agenda item on your meeting.
Right, and you can just, thank you, and
We'll consider that later.
yeah, we'll consider that at a public meeting, or,
Yeah,
I mean-
you have to. Those are some of the discussions we have, who goes to what events, how many people do we have? Does it
right,
matter?
limiting the number to
Are we
that
pay
attends.
for a ticket? I mean, just things like that.
Limiting the number that attends is usually a good way to do it too.
Uh-huh.
You could have a rotating schedule of people signing up of, oh, you want to go to that event? And okay,
Right.
well, then somebody else will go to this event type
And
thing.
a lot of them don't have tickets. It could be, they're opening a new site.
Right.
That it's a thank you event, so please come. And so they would like the whole board to come.
Right. It is difficult. Brad did talk about meetings. So you're conducting the public's business, but you also have to keep records about it. They have to include the date, time, and place of the meeting, the members of the public body that were present, and then a summary of the discussion of the matters that were considered. So again, it doesn't have to be verbatim. You don't have to include all of the public comments verbatim or anything like that, but you do have to keep minutes. Mhm.
Do you document the names of the public who are present? They've signed in.
So typically, if there's a sign-in sheet, that's gonna be part of it. Your minutes can document, there's no rule that it has to. If it's something that's important, I think that it should make it into the minutes. If the board thinks it's important, it should make it into the minutes. And then there's also rules about the times and places of meetings, and this is so that the public is aware of when business is going to take place. They have to be at specific times and places convenient to the public. And they're not allowed on a legal holiday unless that's your regularly scheduled meeting. So if your regularly scheduled meeting falls on the
Martin Luther King Day. I have one,
on Monday, whatever the
17th.
third Monday,
Mhm.
third Monday of January, then you can have that meeting. But you can't schedule a meeting for that time unless it's your regular meeting. For special meetings and, sure,
What if you have a situation where your building isn't open, it's closed for the holidays, can you reschedule it?
yeah, if it's your regularly scheduled meeting, you probably want to provide notice of cancellation.
Yeah.
and then,
Or reschedule.
reschedule.
So the best thing to do, you're supposed to adopt an annual calendar of your meeting dates. I
Brad
mean,
skipping ahead.
so ideally, see, we're covering two slides in one. But ideally, what you can do is just map out if there are any issues with it falling on a holiday. And then when you publish and approve your agenda or your list of meetings for the next year, then you've already addressed that and you don't need to change anything, right? You've just moved it to another date and that's fine.
And then for special meetings, am I off?
I
Oh,
know.
yeah. There's Brad's slide. You have to have a calendar. You have to have a calendar of your regular meetings. And you want to post your agenda 48 hours before the meeting, and there are specific places to post it. It needs to be at the office. If you have full-time staff, it needs to be on the website, if you have a website. And any of the media that has requested your agenda, you have to provide it to them. And then it has to be continuously available for 48 hours in advance of the meeting. And this applies to the agenda. It does not apply to the agenda packet. Some people also publish their agenda packet in advance as well. So these are only the requirements for the agenda. There are exceptions for emergencies. You don't have to post an emergency emergency meeting agenda 48 hours in advance, but you do have to provide it to the media as soon as practical.
About special meetings, like not an emergency meeting, but a special meeting.
48 hours in advance.
And that's
And-
the only notice to the public that has to go out 48 hours in advance.
Correct, it's all the same. It needs to be posted on the website. You need to post your agenda. You have to post it at the office.
If there's a media outlet that has requested your meeting schedule, you would also have to notify them of a special meeting as well.
And Brad had said before, for a regular meeting, you can discuss topics that are not on the agenda. You cannot vote on them. For a special meeting, you can only discuss the topics that are on that special meeting agenda.
At what moment in time does something, if you're not publishing your board meeting packet?
Nobody wrote me down on the papers. Listen, my PhD weight loss.com, we're doing Christmas presents. Yeah.
Hold on one second. I think somebody on Zoom is not muted.
Yeah, could mute your mic, please? Thank you.
Okay, now, could you start again, Jason?
Yeah,
Sorry.
so if you choose not to publish your board meeting packet, at what point in time do the documents in your board meeting packet become foiled? Is it after the meeting has taken place?
Likely, well, so I
When
mean-
it no longer becomes a draft. So if it's not a draft and you have, if it leaves your possession and you've provided it to someone, it becomes foilable.
I would assume it's a public record even in an unpublished form.
Yeah, as
Right.
soon as it's no longer a draft.
So if it's a draft as it's presented to the board, it's a draft resolution until they approve it. Presumably, once they've approved it, it becomes an official resolution.
So there's an argument there. The thing I would be very cautious about is the public access counselor has really narrowly defined what that preliminary draft exception to FOIA means. And I think it would be very difficult to justify under that interpretation that a resolution that's intended to be passed at a meeting is an exempt draft, especially when it's something that the board's being asked to take action on.
So I would say that it's probably not a draft in the sense that the document is the board packet.
So once the
So-
board meeting packet is sent to the board, it's essentially every official document.
Yeah, unless there's some other exemption.
No, I mean, the other part, and I don't know if you're dealing with a perennial FOIA issue. Not saying you are, but sometimes that does happen where you get somebody who's just very, very eager to issue FOIAs and, you know, looking for conspiracies behind every curtain. I mean, I would say maybe consider just publishing that packet just to eliminate the whole issue. But secondarily, also keep in mind that under FOIA, you do have 5 business days to respond to a request. So if your board packet's not available for 5 business days prior to your meeting, then presumably the person wouldn't be entitled to receive it until after your meeting.
The act also addresses recording meetings, and this is something that a lot of people don't know or that might actually, you know, concern them a little bit. Members of the public are permitted to videotape public meetings. You can set reasonable rules regarding this, like, you know, like, media has to be in a certain area or whatever, but just so you know, that does happen and it is allowed. And the reason that we go through all of this is because non-compliance can actually lead to jail time, and it can lead to fines too. And this is enforced both by the state's attorney and then by the public access counselor. Also, in case you don't know, there is a OMA training requirement. You all are required to take it. There is one that's administered by the public access counselor, and we've put the website up here, foiahack.ilag.gov. So everything can be done online. You can register online and complete it online. So most meetings have to be open to the public, but there are a couple of exceptions, and these are called closed session or executive session. And we're only gonna, there's several of these that are listed in the statute, but we're only gonna talk about a couple of these. And you have to keep in mind that even though these are exceptions to the general rule, again, these are all narrowly interpreted because you should be transacting your business in the open. The first one is specific employees. And the thing to point out about this is that it has to be about specific employees. You can't go into executive session to have a discussion about the salaries of employees or anything like that. It has to be about a specific employee, or, you know, it could be more than one, but it has to be about specific people. It can't be the budget discussion. It can't be an organizational discussion about how you should organize the entity. It has to be about the specific employee. You can also go into executive session for real estate, and there's 2 separate exceptions. One is for the purchase or lease, and one is for the sale. For the purchase and lease, you talk about whether it can be acquired or not. For sale or lease, then you're limited to price. You can't talk about the larger policy issues. And you can also go in to talk about security. That one's not used too often, but every once in a while it is. And then I think we also added litigation on here. The thing with litigation, this is a tricky one. You can't go into executive session for litigation just because there's an attorney present at your meeting, or somebody said, oh, we're going to get sued. According to the Attorney General, it has to be probable or imminent. And that means that litigation is likely to occur. If you are in, it's easy if you're in a lawsuit, that there's a pending lawsuit, you can go into executive session to talk about it. But if it's just something that's out there, you have to be careful with it. For approving closed session minutes, you can go into executive session to talk about executive session minutes, but no action. And we have okay, I did remove this too. There was recently an opinion that came out that a lot of boards would talk about and approve their executive session minutes in executive session. Some would come out and approve it in open session, that is the way you need to do it. There's been a recent opinion that says that's the way you're supposed to do it. Discuss in closed, only vote in open. There are some other exceptions, but they're not going to be commonly used, and you can talk to your attorney if you need those. To properly enter into an executive session, you need a motion to go into closed session, and then you specify the reasons. I move to go into closed session to talk about specific employees, and then I would cite the statutory exemption to under the statute. And then you take a roll call vote to approve that motion, and then once you go into executive session, you again take a roll call. And again, when you're in executive session, only discuss the topic that you're going into executive session for. It is really, 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 really easy to wander. Or, this part of the discussion leads to something else. You really have to stay on topic. Executive sessions are supposed to be recorded, and then no formal action is taken. If you're going to direct staff, you can certainly direct staff in executive session, and you can take a straw poll, but know that if you take a straw poll, it is not meant to be the end around for a vote. And then once you're done in closed session, you're going to adjourn the closed session by making a motion, and then return to open session, and again, take a roll call so that you know who's there. It's a lot of roll calls when you go into executive session, especially if it's short. It feels like you're just doing it 4 times in a row. You are. For minutes, you have to keep those during executive session also. And so my advice is, if you have a clerk, or if you have the secretary or an executive director, don't kick that person out, because that's typically the person that's going to take the minutes. You do have to keep a verbatim video or audio recording, and you have to keep that recording for a minimum of 18 months. You can't destroy it until minutes of that session have been approved and the mental health board votes to destroy the recording. And then once you have to review your executive session minutes regularly, at least semi-annually. And then at that time, you look at those and you say, is there a reason that these still need to be kept confidential? If there is not, then you release those to the public. If you are in executive session, this sometimes happens a lot, and people ask, well, that was the topic that was discussed in executive session. How do you know? Because you were in our executive session, which means that somebody in your executive session disclosed it. There's not a lot you can do about that. You as a board can't sanction your other board members. But because you are appointed officials, that might play into whether or not you get reappointed. So just be wary of that. And then we'll move on to the Freedom of Information Act. No Freedom of Information Act?
It's a wonderful resource.
It is a wonderful resource. The Freedom of Information Act basically means that any document that you create as a public body or as a member of the public body pertaining to public business, that the public can get that record. So just keep in mind when you're drafting emails, anytime you're conducting public business, just keep that in mind. If it's on your personal devices or on business devices, if you're conducting public business, that's going to be subject to the Freedom of Information Act. So anybody can request that document. So I told you we had a lot of information, and we probably wouldn't get to all of it, and we're not going to. We are out of time.
Yeah, and just, there is a whole other section that we kind of anticipated we wouldn't get through this morning. We put it in your materials for this reason, that it would be a resource for you, like ethics and conflicts of interest, some more information about FOIA. So it's all there.
we figured we'd rather give you a little more in terms of the actual presentation material, just not knowing how far we get through everything. So thank you.
Yeah, go ahead.
I have a question. So I'm back to abstain or pass. If you have a conflict with an agency, how does your vote go? Abstain or pass?
So the conflict is you have some sort of a personal or economic interest in another. Yeah, so, right, I can summarize the last 20 slides in this presentation with this simple statement. If you believe that there is something being presented in your capacity to vote on as part of your board status, I'm trying to pull up the actual statute there, but if you think you have a personal and or financial interest in the outcome of something you're asked to vote on, the best thing you can do is recuse yourself, okay? And a proper recusal means you are not in the room when the matter is being discussed or voted on, okay? And that could even be your employment, right? Your regular job may be something that you may have nothing to do with it whatsoever, and whatever service your company, your employer provides is something that would be a benefit to the agency, right? To the 708 board. There's nothing wrong with that as long as you're not the one trying to set that up. But yes, when that comes up, the thing to do is I would recommend you even put it on the record in the meeting and just say, I'm not going to participate in this, but you do have to exit the room. Okay, you cannot be in the room or otherwise you're counted as having voted.
Thank you.
Good question.
What are some of the guidelines you use if a board member is to be removed?
Like forcibly removed or resigns?
I mean, let's say, maybe misconduct. Inappropriate behavior.
So the mental health boards are appointed by whatever your parent body is. So if it's a county board, the county board chair is going to do the appointments. They're the only ones that can remove. And there's due process. I mean, there's likely going to have to be a hearing or something like that. The person has a due process right at that point.
So there's typically there may be your own local rules for removal. There's also state rules for removal of an official. It's not easily done though. Just make that clear. I mean, it usually there has to be some like official misconduct, some very real cause. Otherwise, it could just be removal at the expiration of a term.
I can, as an add-on to that, the excellent work that in my honest opinion, that your law firm has done for McHenry County has laid out a template for the due process that you just referred to. Because, yeah, the appointing official, whether it's a county board chair or township supervisor, the Community Mental Health Act does allow for removal for absenteeism, malfeasance, neglect of duty, and something else. But what was prepared for McHenry County's mental health board bylaws does list a progression for the due process that was just referred to, which might be a good resource to consult if you feel that you need to report.
And I hope you don't have to.
No, that's
Like insurance, you have to have it, but you hope you don't ever use it.
Yes.
If the mental health board is interviewing a candidate for employment, is that a public meeting? Can it be done in closed session or is that?
So, right, so
Could you repeat the question, please?
yeah.
If they're interviewing, if the,
Any of this discussion, so it might be good.
I'll get that.
If you don't mind capturing the question.
Sure.
Thank you.
if the question was, if the mental health board is interviewing an employee, does that have to be done in open session or in closed session?
So it can be done in either, would be the short answer. So you can have this as part of an open meeting. But it is a public meeting regardless, as long as there is that majority of a quorum who's participating in that process. Now, a way to not make it be a public meeting would be to have a subcommittee of the board, maybe 2 members, who are basically the advisors to the rest of the board as to who to hire. They go through the interviews, maybe with somebody else within the agency at the staff level to avoid the Open Meetings Act requirement. And then maybe based on the level of that, position, maybe that's something you could then report back to the board in closed session to talk about that review before whatever actions taken in open meeting. Does that answer your question? Yeah.
And just to add on for the open meetings, for the Open Meetings Act, for the exemptions that allow you to go into closed session, those are available to you, but those are not required. You don't have to go into closed session. But those are the exemptions that allow you to, if you so want.
For our board members require them to sign a code of ethics and a conflict of interest statement, so that you have that as some support if there's any issues that arise.
So it was just there are some boards that require you to sign a code of ethics and then also conflicts of interest. That was the comment that was made. Yes.
Can you repeat again at which meeting the minutes from a closed session are approved? Is it approved at the next closed session meeting or next?
Generally, what happens is you review closed session. The question was, when do you approve closed session minutes? What generally happens is at the next meeting, just like with your regular meeting, at the next closed session meeting, it doesn't have to be at the next meeting. You would review the minutes of closed session and then come out of closed session and vote to approve them or not to approve them. This is the semi-annual review because you don't always have closed sessions. Is that what you were gonna say?
Right, I was gonna say, especially with some of those 708 boards, you may have closed session once a year. But the reality is the law requires you to at least semi-annually, every 6 months, review your past closed session minutes. And this sounds absurd, because what ends up happening, and we've seen it happen, where you're creating closed session minutes when you're doing your semi-annual closed session review, and you may not even be reviewing minutes other than your past closed session minute review. But that's what the law requires. So what Brandy said is 100% right. You can just do it at your next closed session, but you may find it actually more reliable to just set on the calendar every June and December. We're gonna go in and review our past closed session minutes, just so it's a regimented, and you don't miss it that way.
And it's also a good time to review previous closed session minutes that you kept confidential to know whether or not those should be released. Yes.
I have a question back to the recusal question. If the chairperson has to recuse himself and leave the room for the discussion and the vote, is it a complicated procedure to basically hand the gavel to someone else?
So, right, what the standard procedure for that, when the appointed chair is not available, and it could be they're missing the meeting, they have to recuse themselves for an item. The other board members at that point vote on an acting chair. Okay, and that's just, hey, I appoint Susie to be acting chair in Bobby's absence. Second vote, that person then basically is in the seat of running the meeting or whatever, if it's the entire meeting, if the chair is absent, or if it's just a one action item.
After that issue is resolved, then the chair could re-enter.
Correct. The acting chair status would automatically expire on the duly appointed chair being present. Yep.
I don't know if there are any more questions, but again, thank you. I remember taking your similar course back in 1997. when I was first elected to a village board that you represent and you still represent, 25, 26 years later. I do thank you for this. I think Jody will collect some feedback and I think, we have we'll have some suggestions, constructive recommendations that this is done in the future. But I do think, I know we're getting short of time here, so I just want to thank you before we.
You're welcome. Thank you. Yes.
I have a question about FOIAs. So if someone submits a FOIA to whomever, is everything open to being given back to that person, including text messages maybe sent from just one board member to another? Or is it only what's being discussed amongst all the board members? Does that make sense?
If you're creating the question was, what is subject to FOIA? If including like text messages between two members. If you're creating a public record, if you're creating a document, it's subject to FOIA. So if you don't want your text messages to be FOIA-able, then make a phone call. All right, thank you very much.
Looked like they were saying things like they couldn't hear.
Thank you guys so much. I appreciate it. And we have, your presentation that we'll share with everybody, afterward, and the link to the recording. So you'll all get a copy of that.
Thank you, everyone. Thank you, Jody.
Thank you so much. I am going to stop this recording. You want to come up here and say something? Ready? Yeah. Okay. I'm gonna stop this recording real quick.
We are thinking that maybe rather than call the meeting to order and then take a little break, why don't we just take a break now and then come back in 10? Can we do 10? Okay, thank you, everyone.
Those online, in case you didn't hear, we're taking a 10-minute break. That's it. Yeah, oh, I